All right, why don't we get started and people will just kind of join and because I know Alan, you have a lot to speak about. And also I just wanted to say it is Alan's birthday today too. So happy
Happy
birthday.
birthday.
Yeah, I'm aging in reverse now, counting down.
Yeah, counting down. Yep.
Right. So Alan's gonna, lead the discussion about imputing income and implications in our practices and just talk generally and set like a framework. And the whole goal is to have an informal discussion and to also tie it back to the work that we do. And we're gonna try to integrate questions along the way and comments. So any comments or questions that you can put into the chat. We also have a hypothetical that I'm going to put into the chat for you to take a look at. And I don't think Alan needs a more of an introduction. Alan, is that okay? Is this enough
I think
information?
everybody knows who I am.
Yeah, I know. And we're
And
really
despite that, they've tuned in today.
no, this is going to be great. So good morning, everyone, and we'll get started because there's a lot to talk about, and we want to hear from you too. Again, so put it in the chat, and we'll integrate questions along the way, and certainly at the end. And we might even need to have a part two because it's a very full discussion that we're going to have today.
So I won't
Okay.
rush through it. Good morning, all, and
Okay.
thank you. But thanks
Yeah.
for having me. As Melissa said, this is a really important discussion. We've come across this every day of our professional lives when we're dealing with support, and the support is child support and maintenance. So the imputation of income affects both. We've sat through a lot of Tim Tippen's seminars and listened to a lot of the cases that he's talked about. I'm going to mention some cases as I go through this today. When we deal with these situations in court, the court does have tremendous amount of discretion. That's the main word I would say here as to what the income that will be placed in possession of the parties, and from that, how child support and maintenance is determined. It's not just the W-2. The statute defines other income that's included, but beyond that, the court is not bound by anything you say in your net worth statements, your W-2s. The court has discretion to include other income. So one of the aspects I think I'll talk about first is where a court imputes income based on employment and earning capacity. If court determines that your statements of net worth and how you report your income is not reliable, they can look beyond that. The courts estimate what a parent's true income is based on their skills, experience, education, and employment history to ensure a fair support amount. So what do they look at as reasons for imputation? If there's voluntary unemployment or underemployment, person quits their job, takes a lower paying job at or around the time of the commencement of an action. If you fail to seek employment and you have the ability to seek employment, the court's going to look at that and impute income. If the information that you provide on your net worth statements or financial affidavits, if you're in family court, is not credible or not consistent, which, for example, you show more expenses than income, court's going to look at that and possibly impute income. And there's also an element that we've seen in our practices every day of disguised income, using a business to hide income. So what does a court do, and what should we as collaborative professionals do? We need to look carefully at the financial records that are provided. The tax returns, either the personal returns, the business returns, the pay stubs, financial disclosure affidavits, that gives us the basis to determine what the income is. And then we look at and we try to assess factors like the party's education, job training, employment history, previous salary, job skills. And we've used vocational experts sometimes to determine what a party's proper earning capacity is. And we also analyze the party's living expenses. And that's what we try to do at the start. So I wanted to just talk about a few cases in this particular area, because I'm going to talk about this first. Then I'm going to get into inheritances and how they are looked at as adding income to determine child support and maintenance. Then after that, I have a really interesting case that I wanted to talk about. That's a fairly recent case, Judge Chesler in New York County, that looks at capital gains and how capital gains could affect the income if it's a one-time capital gain that increases the income, the court will look at that, and the court will use that to assess what support would be. And that case also is interesting in using a very, very high cap. So we'll talk about that. And then I think the main event here really is talking about how gifts and third-party contributions can factor into a determination of what support would be. And they're interesting cases, but we'll get into the hypothetical. So as far as the imputed earning capacity, there's a case, second department case, and I'll give everybody the cases. Afterwards, I will put together a summary of all the cases and the citations. So this case is a second department case, very recent in 2025. There, it was a family court case. Support magistrate found that the unemployed father should have income imputed. And why did he do that? The support magistrate did that because the father had a valid real estate license, worked in the real estate industry until 5 years prior, and the job search materials indicated that he applied for positions which he lacked qualification. So it was some on his part where the support magistrate was not happy with what was presented. And there, the imputed income was upheld by the second department because the father had this license and worked in the real estate industry. Another case, Piraino, P-I-R-A-I-N-O, was a case where the mother had left her job, left full employment, which was at minimum wage, during COVID to help her children with virtual schooling, and she remained unemployed until in-person school returned. So there, in that case, she was working part-time at $20 an hour, and the court felt that they weren't going to look at the part-time income, but they would impute full-time income at minimum wage. And again, that was a third department case in 2025, and the court said the imputation was fine. The next case, a very interesting case, is Di Crescenzo. That is also a third department case in May 2025. And in that case, the mother was a physical therapist who had a master's degree, and she was working part-time to care for the children. The part-time income was about $12,000, and the full-time income was about $95,000. And there, the father wanted to impute $95,000 in income to her, but the court found there that there was an agreement between the parties that the mom not work full-time, that she would care for the children. So even though they look at the parties' past employment history and past income, there they found a specific agreement. And I think that's very important, where the parties are on the same page and there's an agreement. The court's not going to look at it and say, well, you could be working full-time when now you're working part-time and impute income. So that, I think the agreement's a very important aspect of that. But if we look at the next case of Bailey versus Bailey, in that case, that's a situation where there was never an agreement, and one of the spouses had an employment history with a high earning capacity, but stopped working. The court there said that this determination reflects a thorough consideration of evidence regarding the husband's voluntary reduction of his salary post-commencement and a reduction of the wife's income due to her elimination of her job. So the court there said, sorry, buddy, we're not going to accept you leaving your job. That's voluntary, and we're imputing the income. And as to the wife in that case, the court said, business situation was changed. They eliminated the division in which she was working, so they did not impute income to the wife in that particular case. So these are just a few cases that we deal with in collaborative and in court with respect to earning capacity and imputation of income. So sometimes we see the court as being the villain and in the case and imposing amounts of child support that are unfair. In the collaborative process, we have a way of avoiding someone being painted as a villain. And we have our superheroes. And our superheroes, to me, are the financial neutral professionals who can look at the situation and try to work out proper support and fair support. And that's why I think in the collaborative process, it's important that the financial neutrals do really the same work that the parties and their counsel do in court, but can look at things beyond what is stated on income tax returns. So I think I would hold it out to Michael and Nancy and talk about, let's get your input on how you deal with the situations of imputation of income in your calculations and in your preparing budgets for the parties.
And also Sally too.
Oh, I didn't see Sally. Hi, Sally. Good morning.
So I'm going to start, but I'm not sure that I'm going to be able to answer your question because I have a case that, first of all, I'm sure a lot of people, when they're working on collaborative cases or any cases, there's someone that always ends up getting laid off, which is another question about imputing income, right?
Right.
And like you said, are they looking for a job or what's happening? I'm working on a case now where the person's 55 years old and got laid off, was making about $400,000 a year, bought a new home against their financial planner's instructions. Hold on one second.
Close the door.
Against their financial planner's objections. And of course, I ran the model that said it really didn't work, but decided to buy a very expensive house to be at par with her spouse. And then also wanted the lifestyle of the spouse that's making over $1 million. They have 4 children, round-the-clock childcare. So the children's expenses alone, and with the add-ons, are about $15,000 a month. Okay. And originally there wasn't going to be any maintenance, but there was going to be really developed caps because, oh, sorry.
That's okay. I'm back.
Okay. So we're still working on things because the person got laid off. But the question is, the other attorney who is looking out for the interests of her client doesn't want a cap, wants basically the moneyed spouse to pay for all the expenses basically of the new home and child support, which to me is unconscionable because, first of all, when I look at a budget, there are certain things as a financial planner I would do. If I lost income, where am I going to cut my expenses? And is everything realistic? If I'm not making any income, or even if I'm making $150,000 in this situation, let's say if you imputed income to her, should she really be entitled to a $25,000 vacation that she has in her budget that the other spouse is going to be paying for? So to me, it's a big conundrum of how to handle this, which is one of the reasons why I'm on this call. But to answer your question, as far as how do financial people, handle it, we look at the needs of the parties. We look at the budget. I look really strongly at the budget as far as what can be cut, and how to make ends meet, because that's what you would do if you were living together and you were missing that income. But a lot of it depends upon the attorneys and what are their thoughts, because we're the neutrals, but they're the drivers. You know the law, you know how everything is going to be interpreted. We can model and show how things are going to be, but I like to give my financial input as if I'm wearing my financial planner hat on. And how are they going to make ends meet, and what are we going to be able to do?
So that's a great point, Nancy, because in the collaborative process, we're not really bound by the cases that I'm talking about. They're really guideposts as to how we should do things. And before we got on the call, I was talking to Melissa about a case that I've kept in my mind, since it came down in 2014. And it was a Judge Cooper case that was called Sykes. And I think that really deals exactly with what you're talking about, because it looked at the guidelines, it used a very high cap, but the analysis that Judge Cooper made in that case was to look at all of the resources and look at what was available. When we talk about our caps of child support 183, maintenance 228, some of that's very arbitrary, and it doesn't really take into account a lot of other factors that, people are paying significant amounts of taxes. What do they really have left after their federal and state income taxes and whatever else is withheld from their paychecks? And is that all appropriate? And I think we have to look at all these available resources, including the things that I'm talking about here, with earning capacity. It's very difficult when you have a party losing their job and trying to get back into the workplace. Sometimes, depending on age, they cannot find that, and they've established a lifestyle. So you got to be realistic about your lifestyle, and then it becomes incumbent upon us as counsel to make our clients more realistic, either in a court context or in the collaborative context. But I think that's an excellent point. Anyone else want to comment on that before I go on to inheritances?
Yeah, I'll just say, go ahead, Sally, if you want.
Well, no, I just wanted to comment. Thank you, Michael, that I agree with all that, because and then there's situations where, and I have a case right now about that, where the wife really has no capability to earn money. She's 60 years old at this point. The husband's 68 and has retired. And so, but when I look at their budgets, because he's got some additional resources, so he doesn't really have the same living expenses that she does in New York. So when I look at the budgets, I can see that he can afford to do spousal support for her for up to really until he dies, basically. It's a very long marriage, and at least for 15 years. And without it, to Nancy's point, when I look at the projections, I can see she's not going to have any money in 10 years. And he, meanwhile, has a budget where he has net income. But then his attorney is saying, well, the court would not award that kind of spousal support. But the court's I say the court's gonna look at the need. She has a need, he can provide it. So that sort of dovetails with what Nancy's saying, that hopefully the court will see her need and go with that he can provide that for that.
So Sally, this is a litigated case?
It's not a litigated case. It's actually a mediated case. And
Okay.
actually, it's not even that anymore. I mediated the settlement between them, but then when he has a union, so he has a union attorney. When he took the settlement to the union attorney to draft the agreement, they decided to have the union attorney draft it because it didn't cost anything. And this is what happened. And so now she's had to hire an attorney, and who knows what it's going to be. It could be negotiated. So
Yeah, it's a very difficult issue, but I think you raised a point that's appropriate for what we're talking about here. He has other resources. And the courts look at those other resources. So they will, if this goes to court, look at the other resources he has available to pay maintenance. The other aspect of it is obviously it's a long-term marriage, and there are guidelines as to how long the maintenance will be required to be paid by the court. And that's why I think in the collaborative sphere, we have a lot more flexibility to deal with that based on these resources and based upon the need of the parties. And I think we can go out sometimes even longer if the resources are there, so that, the spouse who's getting support might need that for a longer period of time.
right. And but this other attorney who's a big litigator says he is retired. He does not have to work. The court will not, make him pay spousal support longer than 2 years when she can start getting his Social Security, but she could also wait. But anyway, yeah. So
This is a whole nother topic.
The resources will count.
This
noting
is
that.
this is a great topic. I think we need to also cover this topic on maintenance when parties are older. Do we go up to only the full Social Security age? Do we go past that? That in itself, I think, could be a topic in the future.
December. Okay, but so
Michael,
Michael and
Sure.
then Kathleen.
Yeah, I just want to say, as a financial professional, I typically get involved with cases that involve business valuations. So my input in those cases is I am typically going through the books and records, finding what the non-business expenses are, so that the parties can see um, what income the business is kicking off. The other thing that I will typically do is to estimate what the reasonable compensation is. And from my experience, the attorneys would simply take that number. But in course, in a collaborative setting, that's not necessary or always done. Third is where I found in the cases where maybe business hasn't involved or the income is high, it's really important to do a detailed short-term budget for both parties and let both parties see it so they can understand the financial resources of the other party. And then as well to do a longer term budget to see how that affects them. The paying of maintenance and child support over a longer term is also very important. And to be able to share that and communicate that with both parties.
Yeah, I
I-
agree with that too. Running those projections out, and that was the case I just talked about, to let them see that she's going to run out of money in 10 years, and that's so, so important to do. And to Michael's point about the business, I do a similar thing. And in some cases, people just immediately want to go to, have a business valuation. But sometimes I say, well, no, let's just look at the tax returns, the pay stubs, the compensation, and let's see if we can figure this out before doing a full-blown evaluation, because maybe that's not needed depending on the type of business. So,
Thank you.
that can make a lot of sense.
Kathleen?
So I want to thank Alan and Deborah. We have been doing since 2008 a hypothetical where the husband, shockingly, Deborah, has a construction firm and there's the imputation of income. And the one thing we haven't talked about, which is a big deal for me, is okay, client comes and says, John has a construction firm and he's been not declaring 50,000 a year. And I say to my client, yeah, but you've been signing the joint tax returns.
Mhm.
So, Alan, how does that impact? To me, that's a really good sales point for me to do collaborative because I say, you can't go into, I can't represent you on a net worth statement and
Right.
certify your income when you're telling me you made another $100,000. So let's do collaborative and let's work it out.
That's an excellent point because that in court, that could sometimes be leverage, sometimes not, if both parties sign tax returns. But whether it's one party or the other party, the court has the right and often the obligation to make a referral. So
Exactly.
that should, scare the heck out of these people to have their finances looked at by a court and possibly be subject to criminal prosecution. And that's why a lot of people should select alternative dispute resolution, do either mediation or collaborative to address that. And Michael's point and Nancy's point and Sally's point, this is upon us all the time when we practice in this area. These support calculations are very difficult. It's painful for the parties, and we really, when we do collaborative and we get to what's important to people, there's a fear on both sides. And the fear on the side of the payer spouse is, I'm not going to be able to afford this. This is like, I can't do this. If you're in court, that's more of a problem than it is in collaborative. And on the recipient spouse's point, this is not enough for me to live on. How am I going to do this? Where am I going to live? How are my kids going to survive? So that's our job in the collaborative sphere, and using the whole team approach, using counsel, using the parties, using mental health professionals to deal with the concerns of the parties, and above all, the financial neutrals to do what Michael and Nancy and Sally have talked about, preparing these budgets, which are very important to be realistic about things, cut back on expenses where need be, look at what the other resources are. So yeah, very important. So speaking of other resources, inheritances. Let me move on to that, segue to that topic, which is a rich topic. Great case in 2001 was Cody versus Evans Cody, and that's been a Second Department case cited all the time. And the Second Department there said inheritances are not included in the combined parental income used to calculate the basic child support obligation. Everybody knows this, but where it's determined that there's not enough there for support, other resources can be looked at. And courts have looked at not just the income that's generated from an inheritance, which is additional income to the party, but they'll look at the principle of the inheritance and make an award based on the principle of the inheritance. That could be problematic. I think there are two schools here as to how this is looked at. I think if the inheritance is not being used to support the party's current lifestyle, there might be less of a chance that a court is going to look at the inheritance as part of it. Not fully, but there's a case here that I've also looked at, more recent, Weisbach case. In that case, the court says the usual things: determining a parent's support obligation, a court need not rely upon a parent's own account of his or her finances, but may impute income based on the parent's employment history, future earnings, educational background, or money received from friends and relatives. So we're going to get into that. But the money received from friends and relatives could include inheritance money. And in this particular case in Weisbach, $70,000 per year were contributed to the household expenses from the inheritance. And I think the court there in the Second Department, as the court in Cody, their conclusion is if you're going to use that inheritance to fund your expenses prior to the commencement of an action or the stop the clock date, we're going to include that as a resource available to pay child support, like it or not. That's how it seems to come down here. And I think as collaborative practitioners, we have to also be aware of the inheritance. I said my first thought was, yes, if you have an inheritance of $1 million that is invested and you're throwing off 5% a year, that income's available. I don't think there's any question that income should be available for support purposes, child support or maintenance. And that ought to be included in addition to your W-2 income.
I just have a question. Is it differentiated if it's used for child support versus spousal maintenance?
I don't think there's. I'm sorry, I didn't mean to.
No, I just wondered if it's like, yeah, well, if you're using it for expenses, we'll impute it for child support. But I'm wondering if it's differentiated for spousal support.
I don't think it's differentiated because it's looked at as the whole support package, and it's then divided between maintenance and child support, but it's included in income for the purposes of determining support.
Right.
Okay.
And it's on the tax returns too. The income from that inheritance is on the joint tax return. So that income has been being taxed and both parties are paying that tax. So that should add to that it can be used.
And I think that in the collaborative sphere, I think we should be looking at tax impacting things to make sure what's really available and not ignoring that. So any other questions about inheritance before I move on to the next topic, which is this great case from the end of last year that deals with capital gains and the statutory income cap?
I think we have Kathleen, Karen, and Carmen, but I'm sorry about the order. I'm just looking. So
That's okay.
Do the order.
So I just wanted to clarify, um, separate property is not subject to equitable distribution, but it's
Exactly.
totally subject to maintenance and child support.
Absolutely.
Carmen, did you want to share something?
Yeah, so kind of dovetailing off of what Kathleen just said, it's my understanding, and I haven't found the case, but if let's say the beneficiary has been actively involved in the trust, and so you have that whole active passive, that then not only is the income going to be brought in, but the principal too. And therefore, that to me is the most troubling situation. And I was wondering if you've had any experience with that.
Not I, but I would say that if they're using the principal and income of a trust for supporting the lifestyle, then I think it's easier for a court to say, you've already done it. So we're doing it.
Yeah.
We're going to do the same thing. When we counsel our clients on inheritances, what do we normally say? We say, well, it's your separate property. Don't commingle it. We don't want that to become
Transmute.
part. We don't want it to be transmuted into marital property.
Yeah, but
And
it's a little late when it's already happened, right?
I
Like
understand that. Yeah, that you can't
then what?
rewrite. And in the hypothetical, it was a little late in some respects. But I think you just be as careful as you can be, give the advice that's appropriate advice, but then you don't know later on what a court is going to do based upon your financial situation at the time, because the financial situation may change. If a party who has the inheritance then loses a job, where's their support going to come from? How are you going to deal with that? Are you going to look at the inheritance? Maybe. It's still that I think the jury is still kind of out on that one.
Nancy, did you want to share?
Yeah, I have a question. So, what happens if the person has the inheritance and their spouse is an investment advisor? So they're actively managing it, and also it has to be under their broker dealer because of compliance reasons. So, how is that handled? Or, on another note, what happens if they both go to the same investment advisor and they're talking about their financial picture and they're saying, well, we would revamp this, we would do this, and they're involved in that? How is that handled? Right,
Well,
Carmen?
Exactly, Nancy, exactly. And then, to Kathleen's point, does it get brought in for equitable distribution or not? I mean, that's the question. But my point is, it's not so clear.
Yeah, I think for equitable distribution,
It's clear.
it's not so clear, nor is it clear for support purposes with regard to an inheritance, unless, as one of the cases I talked about says, if you're using it for lifestyle, then we're going to use it in the final calculation of support. All right.
I think Karen had the
I just have
question.
one
Oh, Karen, sorry.
Sorry, I have a case that's actually at 10 o'clock where it's they're living very like modestly. The moneymaker is a physical therapist, and the non-moneyed spouse is set to have a very big inheritance, and the moneyed spouse keeps wanting to bring up like, I'm going to be paying all the support and like barely making by, and like I know that in X number of years you're going to get this huge inheritance, and he wants it to come into play with all of his support that he doesn't want to be paying.
That the courts wrestle with that all the time. It's a prospective inheritance, but you don't know when that inheritance is going to occur.
Right. So he is
So
on the hook for.
I would bring it back. I would bring it back to the collaborative sphere and say, our agreements can look into the future also. We can say, if there's an inheritance, then how does the support change?
Mhm.
Yeah.
We could take that into account, whereas the court's not usually going to. I've not seen courts do that. They can discuss prospective inheritances and kind of bury it within a calculation, but I think we can be more creative in looking at that because, inheritance, someone, you could say, oh, the parent is 80 years old. They may live to 100. You may not get that inheritance. So I think that's something we can deal with in our agreements.
Or Karen, they could marry somebody that the mother-in-law absolutely despises and then kind of make modifications to the trust, which I've done.
Right. And when we get to the gift part of this, there's the way the courts come down on it is kind of interesting. But let me turn to the GB case, which is a case really about including capital gains. This was a Judge Chesler case from last year in New York County. The parties were high earners, but the court still wasn't satisfied with what was disclosed on their income tax returns. And the court went back a few years and saw that there was a capital gain amount on the tax return, and their income in that particular year was over 5 million, whereas it was in the last 2 years before that return was, about 1.5 million. So the court said in that case, and the parties had significant assets. The husband had 13 million in assets. The mother had 2 million in assets. They both had, significant enough earnings. But the court added, for imputation purposes, above and beyond their reported incomes. And the court came in with about 900,000 for the husband, even though his W-2 was $500,000 less. And the court bait on 1.5 million. And this was a temporary application, which was interesting because the courts don't have to look at the guidelines necessarily in a temporary application. They looked at this really almost as a permanent application for support. And in this case, the father had argued that he didn't need to pay a lot because if you use the $183,000 cap, and he would have shown less on his income than the mother, that he should be paying about $988 a month, which to me brings in what I like to bring up Tippins when he said he imposes what's called the son of a bitch rule. When someone makes an argument like that, they usually end up getting punished. So here, the court not only imputed income of $500,000 based on the capital gains that were shown on an earlier return, but the court looked at a cap of $650,000, which is a pretty high cap. In Westchester, we're talking about $350,000, even on income that might be over $1 million. And I always look at these cap cases and I marvel that some of these courts go even above that. There's a case that's cited within this GB case. It's called Clower. I didn't see this one before, but in 2017, there was an $800,000 cap that was affirmed by the First Department. So there's an interplay here between the imputed income and the cap that we really have to be aware of. And I think in the collaborative sphere, we really can, I don't think we necessarily need to be bound by caps if we use the same approach that I was talking about being used in Sykes in court, and we look at all the available income, we look at the reasonable expenses, we pare down expenses if they're outrageous expenses, and the financial neutrals can come to fair support without really, looking at whether we should impose a cap of 300, 350, 600, 800, because it's really based upon the party's lifestyle and how they've, spent the funds that are available to them. So that, to me, very interesting case, and I'll give you the citation on that case. I don't know if it was appealed. Still kind of a new case, but it would be very interesting to see that. And I think I know the attorneys who were involved in that case in Manhattan. So that takes us through the imputation of income for the purposes we've discussed: earning capacity, inheritance, capital gains. The next thing I think is, I don't know if Melissa, did you put up the hypothetical there?
I did. I put it in the chat. Can everyone see if they're able to access that? Yeah. All right. So thumbs up, yeah? Or no?
Okay.
No? Okay. All right.
So assuming yes, this is a little more realistic than a hypothetical, because I just dealt with a case in front of Judge Heyer where this third-party gifting became an issue as to support. The parents here, the incomes would have generated a very, modest amount of child support and actually no maintenance whatsoever. And the parties had about $750,000 in equity. There was a lot of separate property claims that were made by the husband, Mark, because he had owned property prior to the marriage and used the proceeds of that property to invest in the marital residence. Issues arose as to that, whether certain amounts of that were commingled and transmuted. There were many, many interesting separate property issues. But one of the things that was a big issue between the parties is that in the last 3 years, Mark's mom, Joan, inherited funds from her father, Mark's grandfather. And there were significant funds that were inherited by her. And during the marriage, there were no such funds available to Joan. She was a teacher, and she was generous within her means. But once the inheritance was received, she was more generous with the children. She gave both of them. She gave them both Christmas presents. She paid monies for the children's camps. She made other gifts. Some of the gifts were used by the parties for renovation in the house. And, thus the issue came up. What, if anything, ought to be imputed as additional income to the father for the purpose of payment of support and or maintenance. And the parties felt they had a divergence of feeling. Mark's position was, my mom was very generous with what she inherited from my grandfather, and he himself inherited some funds from the grandfather, some of which he used to do the improvements in the house. And the payments that were being made were over 3 years in a 20-year marriage. And Mark's position was, I don't know that these will continue. And of course, they didn't continue. They kind of ended when the marriage faltered. So there were no more payments that were being made, but they had a 3-year history of how much the payments were. And Mark was upset. Whereas Mary, her position was, I know these gifts are going to continue. Your mom just stopped, and you're going to have those funds available. So I think, it's fair and appropriate that you pay me not only a little more child support, but I want some maintenance. And this is a long-term marriage. So this was a big issue. So again, in the litigation context, it was, we had our cases and the other side had their cases, and the judge sat and listened to both of us. And he said, I don't know what I would do after a hearing. You're going to bring mom in to testify about these gifts, whether they would continue. So it created a big issue in the case. And I can tell you that the case ended up getting resolved. And once we discussed this hypothetical a bit, I want to talk to you about the cases that we cited to the judge. And I don't think there's any definitive resolution here, although I felt from our side that the case law we cited was pretty good. You never know what comes up on the other side, and I'll give you what comes up on the other side. So I throw that out to everybody and see what your thoughts are on this gift giving. And I know, Melissa, you have a case that involves something along these lines too.
Yeah, actually, Ivan, and I are involved in a collaboration that involves a parent. When you have a parent who lives with the family and their contributions to the household, and there's not necessarily any titling on the deed or anything. It's just that the mom lives with the family and contributes X amount and has been for a historically period of time. And they're going to be selling their house, and it's very likely the mom will continue to live with her daughter in the same kind of arrangement. And then how do you consider that contribution? Because but for the mom's contributions, they would not have otherwise been able to afford remaining in the house. Ivan, I don't know if you want to share anything else about that.
No, I think you've summarized it well. Yeah.
Yeah.
So let me ask the two of you, have you done the research on the case law to see what the courts say on this.
Well, it's interesting because, and this is something, Ivan, I haven't spoken to you about. This is what I learned. I think that his client went into ChatGPT and asked the question and came up with a response that she thought was supporting of her position, which was basically that nothing should be contributed, third-party contribution should not be factored into any kind of support analysis. And because we were kind of considering that, she really became very upset. And basically, I think the collaboration is really has ended on that issue, unfortunately.
So perhaps, I don't know if this works. I mean, you can look at the cases. I know what my opinion is about that based on the case law, but maybe you can enlighten them both as to what the courts have said as a way to get them back to the collaborative and guide them a little more appropriately and realistically. You know, people.
Hey, Alan, tell us what's the case law say?
Oh, you want to hear about the case? Okay, I'm happy to tell you about the case law. This is good. It's good because I have. So there are a few cases.
But but before we get there, Alan, I'm just curious, Ivan, what your client, what was her like? Why was she so upset? Like, can you talk about what her perspective was with that, and why that was just it was infuriating that would be considered.
Well, she really didn't give me much time of day. The fact that I wanted to have the conversation was evidence to her that I wasn't really looking out for her, and that she was A, in the wrong process, and B, had hired the wrong lawyer. So, there wasn't really the opportunity to really get underneath what was going on. But I can tell you that it was along the lines of, what Alan was expressing in the hypothetical, which is, look, we don't know what the future is going to bring. And my mother's under no obligation to do this. And I don't want my mother's generosity to serve to benefit my no good ex, to limit his obligation. And if you even want to talk about that, you clearly don't understand, me or what my family's needs are. And thanks, but no thanks. So,
well, she should read the MM versus RM case from Judge Patel from May of 2024. And that was one of the cases.
Let's hear about it, Alan.
Besides the other cases. In that case, the family of the spouse who was in the residence was paying rent at about $156,000 a year. And, Judge Patel cited some other cases, and this is where she came down. I'll read from the decision. Defendant seeks the imputation of considerable income to plaintiff based upon her family's continued financial support. He argues the plaintiff should not be permitted to hide behind statutory calculations using the income reported for tax purposes. Defendant points to the well-settled principle that the court may deviate from the formula used to determine a non-custodial parent's share, seeks an order imputing to plaintiff based upon the totality of her financial resources, including grossed up income needed to cover after-tax fair rental value of her home and monthly expenses. In that case, they even had an expert testify as to what the fair rental value would be for the home that the father purchased for her. And the court, here's the conclusion, and this is key. In determining whether to impute financial contributions from a third party as income to a parent for the purpose of calculating child support, the continuing reliable nature of the financial assistance is of paramount importance. So if that is going to be contributed, the funds for the rent or rental value, then a court's going to look at that and likely determine that they're going to, this is, historically, then it becomes a question of, is 3 years historical of a 20-year marriage in my hypothetical? The court then cites to a Judge Sunshine case in Brooklyn, Jennifer D. versus Maurice D., where in that case, the judge there was a lot of financial chicanery there, as I could see, and the business was paying for a lot of the expenses of the husband, and we've talked about that earlier today. There, it said, Judge Sunshine warned against imposing an unjust result by conflating conflating the imputation of ongoing financial compensation from a family business, okay, that's going to be included, with the imputation of passive lifestyle benefits a party may enjoy by virtue of his or her relationship with a non-party where there is no obligation to continue the benefits. So that's the distinction that's drawn in this case. It's drawn by Judge Sunshine in the case of Jennifer D. and Maurice D. That's a 2021 case. And then it also there's an older case that really addresses this very particularly. That's Ubsher, Huebsher. In that case, the court determined, this is a First Department case, plaintiff's testimony that defendant's wife's mother had provided the couple with annual gifts during the course of the marriage, coupled with other evidence of past generosity, was an improper basis upon which to impute such income to the wife for purposes of establishing the proper level of child support, as it is assumed that such gift giving by defendant's mother would continue in futuro. In any event, since the mother had no legal obligation, this income source should not have been taken into account. So there you go.
Mm-hmm.
There you go. That's to me the distinction. And okay, does that settle it? I don't know. Take a look at Costello versus Fong. That's a 2022 First Department case.
What's the name of it?
Costello, Castelloe. I'm going to give you all, Andrew, I'm going to get you all the citations of everything that I talked about today. I'll put that all together so you'll have everything. There, again, there was a gift giving, and there was a referee. This went up to the First Department. Judge Katz, I think, was the judge on the trial. He sent it out to her. The referee properly imputed income of $250,000 to defendant based on cash gifts he received from his parents during the 3 years preceding the hearing, and omitting earlier gifts used to purchase the residence. So those gifts were looked at as additional income, which seems to be contrary to MM, Jennifer D, and Ubsher. So your guess is as good as mine. You know, if you're in court, you argue the best way you can, citing all these cases and applying particularly to the facts in your case, as I did in this hypothetical, which was a real situation. And I would just say that I don't know how many of you have been in front of Judge Heyer, and some of you still practice litigation. His pitch is always, okay, you want to spend $150,000 to get my answer on whether to include these gifts. Good luck, and you never know how it's going to come out. So I want to send you out in the hall and have you make a settlement. That's his way of dealing with it.
Nancy, did you want to share anything? Kathleen, you're not a fan. Okay, Nancy, did you?
So, to your case, Melissa and Ivan, you know, when you're doing the budget, and let's say, I mean, I don't know where she's living or she's intending to stay there, but if there's a shortfall, okay, you say, listen, if you still want to live there, you know, you can use your principal, you can use income, whatever, get a roommate. And in this case, the roommate would be the mother that's contributing to cover the shortfall.
Yeah. Well, we were going to have a meeting with the financial neutral, and she really didn't even want to. And I think there were reports that were illustrating all different options, but she didn't even necessarily want to even explore that. The fact that it was even considered in any way was just not acceptable. So, but yeah, I think the financial neutral's role in the process is so pivotal in just illustrating all different options and exploring and being in that brainstorming space. But when you don't have someone who's like kind of willing to even be empathetic to the other person's needs, and it's hard. I mean, she was frightened. I mean, I understand it. It was a bad place for her. So we'll see what happens.
Melissa, Ivan, do you think that if you had known about these cases and kind of headed her off at the pass before she went down the AI path, that it might have made her a little more realistic about it? Or do you think that would have been a lost cause anyway, because she was just positional and was not going to look at it differently?
Yeah, well, I didn't know until what Melissa just said this morning that there had been an AI inquiry involved. I thought she was getting legal advice
Yeah,
from
because
someone.
she wasn't getting
Yeah.
it from that person.
Yeah, she wasn't getting it from me, but she was coming at me with
Yeah.
legal information, but she was not interested in hearing the other side. In fact, I think the fact that I would even consider looking at the other side proved her point, which was you clearly are not my lawyer. Um, and yeah, she was she she was gonna hear what she wanted to hear, and she wasn't really interested in having a discussion that wasn't going to end the way she wanted it to.
Well, she obviously didn't understand either what the collaborative process was all about.
Oh yeah,
Yeah, no, she
that's
went in, but she went into it talking a good game. But
Yeah.
then yeah.
yeah, definitely. Mark, did you want to share something?
Yeah, no, I was thinking about AI, and I was thinking maybe we should be telling our clients at the very beginning that, caution about AI, because we know that AI is not always reliable as for legal research, and sort of try to head that off at the pass.
I think that's a really good point.
Yeah,
Really
yeah,
good.
Yeah. Because you can get AI to tell you almost anything you want it to, depending on how you phrase the question.
that's
Mm.
right. That's right. That's a whole other topic, but yeah. So, I know we're approaching 10 o'clock, and Alan, did you have more to share? Is there anything that, just to conclude with our time today, and or to identify also some future topics that we might dig a little deeper in from what we discussed today to kind of unpack a little bit more and to share?
I think surprisingly, I got through the material that I prepared. If I spoke too quickly, that probably enabled me to get to that point of getting everything done in an hour. So
Yeah.
I think it's a very interesting topic, and I think we should continue to look at it. I think the cap issue is also a very significant thing that we should probably have.
Yeah,
I think we did deal with it. I think we had Judge Grossman in to talk about the cap, and I don't know if we want to get a judge to do that again or have us continue, look at some case law and see where that's headed.
yeah,
Because
that
the
would
we know the cap is changing. You and I, Melissa, are working on a matter where we know the cap is changing, and we're
right, we
adjusting an agreement to deal with that.
for sure. Why don't we close, Andrea? Your hand is raised, so want to be.
Oh, okay, thank you. I just had one question. I was just curious, in a case where the husband is receiving $3,000 a month and will be getting that for the next 10 years from a brother who owes him money, is that considered income?
I hope not.
Because
It's not really. It's restoring something that he gave away. He's ending up even. How could that? I don't see how that could be income. Not that you asked me.
no,
But I'm glad you answered that, Mark.
So since it's like it was separate property of his that he gave away, and now somebody's just paying it back to him, it's his separate property. I mean, it would be considered in the sense that the totality of resources that the person has. But
Right.
You're saying you don't think it would be fair to impute him with an extra $3,000 of income a month? Because I mean, the family lived on it. I mean, they needed it.
Well, is there interest income included in that $3,000?
No, just $3,000 a month for the next 10 years. And it's been going on already for like 5 years. So,
And did the parties use that to live on, right?
oh, yes.
So if the parties used it to live on, maybe there's an argument to be made that it was a resource used, and it's still a resource.
Yeah. So you don't know how it would turn out, in other words, correct?
Whether it's deemed income or not, and it doesn't seem to be deemed income, it's repayment of a debt.
So then it would be considered it's right. So there's no way to know for sure how it would turn out, but it would be considered the totality of resources
Maybe.
of one.
All right. Well, thank you everyone for your time. Wishing everyone a happy Thanksgiving, and hope to see you at the gala on December 4th. Alan, enjoy the rest of your birthday, and
Thank you.
thank you
Thank
for
you, Melissa.
participation,
Thank you, Ellen.
and
Thanks, everybody. Great to see y'all.
Yeah.
take care.
Happy
Bye-bye.
Thanksgiving,
you.
everybody.
Bye.
Yeah.
Thanksgiving. Take care.